SJC-13050, Commonwealth v. Rowen, D. Lowery.
Attorney Mack, we're ready for you. I think you're on mute. There you
Is
go.
that better?
Yes.
May it please the court, my name is Attorney James Metheny, and I represent Rowen Lowery in this appeal. The first issue in my brief concerned the judge abusing her discretion by allowing the Commonwealth's motion in limine to admit statements of passion as a joint venturer. And this will also address the issue in the amicus announcement by this court as to whether passion could be a joint venturer and a victim. I'd be arguing that she did not participate in, I'm going to quote the statute, quote, subjecting, recruiting, enticing, harboring, transporting another person to engage in commercial sexual activity, end quote. And that those two words, another person, are very important here because there's absolutely no evidence she did any of those things to another person. Her crime was basically sexual conduct for a fee.
Well, Mr. Metheny, don't we have to look at the nature of the crime to determine whether or not conspirator statements come in? Because this crime is unlike a robbery or any other crime, where by nature the crime of sexual trafficking requires prostitution plus someone who sells or facilitates the prostitution, right? So how do we take the nature of this crime into account in figuring out whether or not these statements are admissible?
Well, again, I think you have to really look at the statute. I don't think the fact that she's maybe a prostitute.
But
means that
you
she's a
don't have
joint
the crime
venturer.
absent the prostitution, correct?
Right. But I don't see how that makes her a joint venturer in a crime of sex trafficking.
Let me ask you about the search warrant in this case. The issue is whether or not cell phones were used to facilitate the sexual trafficking. Here we have the victim exchanges money, sends a text to someone, then receives a text from someone, and then starts to indicate she can start the session. And then she also says when arrested that a GPS was used to find the location. How is that not the use of a cell phone to facilitate sexual trafficking?
Well, as I argued in my brief, I think the problem here is that there may have been probable cause to search her phone based on.
She texts someone, right?
Right. But
Okay.
there's no
Don't you get to search to see who she texts?
Well, I think you have to get the records from her cell phone first, because there's no evidence, there's nothing in the affidavit of who she was texting.
She
So
gets dropped off by a client, right?
Right.
Then he gets picked up and he's got 5 cell phones in his car, and she's texting someone after being dropped off. And you're telling me that's not probable cause?
I don't think it's probable cause to search 5 other cell phones when there's no nexus between her phone and the other phones. As I said, there's nothing in the affidavit saying that she was texting. They have no proof she's texting him. So what phone out of these 5 phones is she texting? So I don't think there's probable cause to search 5 other phones that are in the car. As I said in my brief, I think the police should have gotten could have gotten a search warrant for her phone based on the fact that she placed the advertisement with her phone number. She's communicating with Lieutenant McManus using her phone, and then apparently texting while she's in a hotel room. That probably gives you probable cause to search her phone, but I don't know where the nexus is between that and 5 other cell phones. This court has taken a narrow view recently in the last 5 years or so in its decisions about what constitutes probable cause to search cell phones. And this court has found that even communication between 2 parties that's proven sometimes is not enough to search all those cell phones. And here we don't even have any communication in the affidavit. And the denial of the motion was not harmless beyond a reasonable doubt because the text or the entire case against my client. This is especially true because Passion testified favorably for my client that he didn't know what she was doing in the hotel room and that he merely dropped her off, that she didn't pay him for the ride. So the texts are extremely important to the Commonwealth's case. Without the text, I don't think they really have a case.
What do we do with the fact that your client dropped her off? He was pulled over and had condoms, lubricants, escort service business cards in his car. And does that add to the search warrant as to his cell phones?
Well, again, I would argue that
That is, it
Yeah.
doesn't look like he's just dropping her off randomly, like on the way to the grocery store. There are other things in his car suggesting that he's involved in sex trafficking.
well, I don't know that necessarily is true. I believe that some of these items were found in her
Well, it's not
pocketbook.
necessarily, I mean, that's not the standard for whether or not you get the search warrant, right? It's not necessarily, it's probable cause.
Probable cause. Again, I go back to my argument that I think there may have been probable cause to search her cell phone, but the 5 other cell phones, I don't see where the nexus is to search 5 other cell phones that are in the car.
Most people don't carry 5 cell phones. Isn't that suspicious in and of itself? That particularly when we've got testimony from the police officer that, you know, this type of business is heavily reliant on phones and how they communicate to set up, you know, the sexual.
Well, I admittedly, most people don't carry 5 cell phones in their car. I would admit that, but whether that,
Well, they don't carry 5 cell phones, escort services, condoms, lubricants, dropping off a prostitute at a hotel. I mean, can we return to the joint venture issue for a second? Because
yes, I'd like to return to the.
there seems to be no cases. The cases cited don't seem to be very helpful by either party. I'm just trying to understand the principle here. And does the fact that this is an unusual crime where one of the participants is also the victim mean that the joint venture analysis is inapplicable? Help us out here, because we're gonna have to think through this as opposed to just look something up.
Well, I would agree with you that there really aren't any cases on point, certainly not in Massachusetts, and the cases that were cited by the assistant DA in his brief really are not helpful because they're cases from other circuits, federal cases from other circuits, unpublished cases, and a case from Mississippi, and they're not sex trafficking cases. And they have nothing to do with admitting statements from a joint venturer.
What's the logic of why we allow those statements in? And is that logical inapplicable in the trafficking context where the participant is the victim? Reason it out for us. Give me your reasons why it doesn't, why we should draw a distinction here.
Well, I think, again, that even though she's participating in this sex trafficking crime by being a prostitute, I don't think that gets you by, and I quoted the statute earlier, what her activity just doesn't comply with what the statute says. She didn't do anything.
Isn't the rationale for the doctrine that of vicarious liability? That if partners in crime agree to commit a crime, then I'm going to be bound by what my compatriot says during in furtherance of the crime? Isn't that the rationale?
But I don't see where her intent is to commit sex trafficking. She has no intent to commit sex
Her
trafficking.
intent is to prostitute herself, and
Right.
and without the prostitution, you don't have sex trafficking, right?
Right. But her crime was sexual conduct for a fee. Again, I don't see how you get to, she's a joint venture in sex trafficking based on the statute and
You have to be a joint venture as to sex trafficking or a joint venture as to the sexual conduct for a fee? Can't you be an aider and abettor and co-conspirator in helping to accomplish that crime, even if as a third person before there was ever a sex trafficking crime?
well, I think that her participation has to go along with what the statute says. I don't think her participation is
Oh,
being.
do we have are there cases? The cases where you have co-conspirator statement doesn't mean that the co-conspiracy statement has to be made in furtherance of the particular crime being prosecuted.
I think that it does have to be in furtherance of the crime being
It
prosecuted.
has to be in furtherance of the conspiracy. Let me ask you a question about the cell phones, if I could. If you're, you keep on saying, and I understand why, that, well, doesn't give them probable cause to search 5 cell phones. Isn't the way to engage in human trafficking like this then, that if you're going to engage in it and you're going to use a cell phone, just buy 10 or 12 other cell phones and keep them with you so that the government can never get probable cause?
Well, again, I would go back to what I said, that there may have been probable cause to search her phone. And by searching her phone and getting the phone records, then they could have seen who she communicated with at the time, and then get a search warrant for that phone or other phones. But to just search numerous phones, I think was improper.
Counsel, can you remind me just factually, was her identification in his car?
I believe it was. Whether it was it may have been in her own pocketbook, which was in the car. I don't, it could have been in her own pocketbook.
Do you want to talk about the expert testimony? Because quite frankly, that's your best argument.
Well, I'm surprised to hear that. I would have thought that the joint venture was the best argument based on the amicus announcement. I thought that's what you'd be interested in.
Justice Lowy is often interested in different things.
Well, the argument was Lieutenant McManus should not have been allowed to testify as an expert and a recipient witness. First of all, there was discovery violation. The judge did indicate at the trial that notice should have been given to the defense because the DA insisted he wasn't an expert. Judge says he is an expert. And it's important to the case because he's the one who explained the terminology in the text, the relationship of a pimp and a prostitute, and how related to the facts of this case. And
But
as
counsel,
well-
counsel, could I just interrupt you on this one? Because this isn't the normal case. Because in this case, the defense lawyer was an incredibly experienced lawyer, one of the better defense lawyers in the Commonwealth of Massachusetts history. So this isn't a surprise to this particular defense lawyer that McManus has all of this experience. He testified or the averments in his affidavit in support of the search warrant went through all of his training and experience in sex trafficking and some of the other ancillary parts of that. So the fact that he's going to testify, I would think that would be a preview that there was going to be not necessarily a melding of the lines between expert and recipient witness, but that he's not coming into this as a regular garden variety beat cop. So is the whole purpose of the notice provision kind of obviated by the fact that we know it's McManus?
Right, that's how the judge ruled that the defense was, I think defense counsel indicated he wasn't surprised because as you said, the affidavits had all of his experience in there. So that's why she allowed it. But as we also know, testifying as an expert and a recipient witness has been disfavored in the Commonwealth. And the
It
case
has, but that's the next point I wanted to bring up. McManus didn't cross the line here, right? In the cases that we've seen that and where we've talked about the disfavoring of that, they would cross the line to the ultimate conclusion that the jury was there to decide. And he didn't do that in this case. So even though it's disfavored, did he cross the line, and was the judge wrong on that?
You know, I don't believe he said anything. He didn't say that Passion was a victim in the case. Basically, he didn't give an opinion about that, no. But he certainly related to facts of this case to his knowledge and experience and training about sex trafficking. And that, again, has been disfavored by the case law in this Commonwealth.
Okay, we all set? Any other questions?
No, thank you, Chief.
Okay, thank you. Attorney Lee.
Madam Chief Justice, and may it please the court. Chief Lee, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. In the sex trafficking conviction before you, the victim's statements were properly omitted against the defendant as statements of a joint venture. Because the evidence established a joint venture between the defendant and the victim. The fact that the co-venture in this case was a victim does not affect analysis. The relevant question here is whether the evidence showed by a preponderance that a joint venture exists between the two, and the evidence showed that.
The judge never instructed the jury, correct?
That's correct, Your Honor. The judge,
This was very important evidence. How is that not a substantial likelihood of a miscarriage of justice?
so the standard is not substantial likelihood here, just because it's not a murder case. The standard is substantial risk of miscarriage of justice, where the defendant did not request a limiting instruction. Here, the evidence were overwhelming where a joint venture exists between the two. The defendant is a manager for escort business. On July 31st, the defendant drove the victim to provide sexual services, and immediately before providing sex, the victim was communicating with the defendant.
So that was error, correct?
It was error. The judge should have instructed the juror to find by preponderance that there was joint venture.
Okay, and you would concede, I would think, that this was very important evidence in this case, correct?
In terms of the joint venture statements from the victim,
Yes.
it is crucial. However, it would not create a substantial risk, because even excluding the victim's statements, you still have the defendant's statements from the cell phone record where he coached the victims through sexual services, told her what to do during the services, and explained to her the terms of the business. Even that statement alone could find a defendant guilty, especially on a social risk standard.
So we have the dropping off. We have the dropping off in her effects in the car. We have whatever was found in the car, plus the cell phone communications.
Yes,
And
and
that's enough to overwhelm the error in the admission of the joint venture statements?
yes, if it was error, yes, there's no substantial risk, because where the victim was transported to provide sexual services, she acknowledged that she wrote the ad to provide sexual services, and the text messages where the defendant coached her through sexual services at different occasions, provided that the defendant had knowledge that what he was doing when he drove the victim to Werewolf Inn in Woburn on July 31st.
So counsel, I just want to make sure I understand your argument. So does that dovetail into the admission of the other text messages? And what I mean by that is, does your argument weaken if those other text messages, if we found that the judge abused her discretion in admitting those other text messages? Does it weaken your argument on the joint venture theory?
It certainly weakens, and it would be the same argument whether it was error to admit or whether it was error to not give a limiting instruction. The standard is all the same here, it's substantial risk. And of course, these statements would have strengthened the Commonwealth, and probably did at the time, to provide more context on the relationship between the defendant and the victim. However, these proposed alleged error did not create a substantial risk, because the text messages still provide statements from the defendant to the victim that will provide context and relationship between the two, and to show that on the day of July 31st, the defendant knowingly drove the victim to provide sexual services. And I believe Justice Kafka earlier asked my brother about what's the logic, what's the policy for admitting these statements. One key point about Rule 801D2E is the community interest between the two. Here, even the victim was a victim because she was exploited by the defendant. The communication between the two in order to achieve the crime here still shows that the statements are minimally reliable. The fact that she was a victim is not relevant in the consideration here. The question remains whether there was joint venture existed between the two, and the evidence showed that.
But you begin by saying there's a community of interest, right? But is where you're the victim of trafficking, is that as simple? I mean, is that the principle we should focus on, whether they have a community of interest? Or because isn't that sort of cut against you with trafficking?
No, Your Honor, because in this case, it was a little bit different from the common understanding of sex trafficking, where the victim is forced to do something. Here, the victim actually participated in the crime. She created the Backpage.com ad. She coordinated the sex trade with the undercover officer. She collected the money from the undercover officer.
You're not arguing it was within her interest to be sexually trafficked?
No, Your Honor, no.
Okay, good.
It was just the communication between the two is reliable to show that the crime was ongoing, and that her statements would show that the joint venture existed. That
More convincing that argument is, the harder the closing argument position is for you.
my apologies, Your Honor.
The more convincing you are about they're partners. The whole theory of joint venture is it's an admission by a party opponent because you're in the thing.
Yes, Your Honor.
And so you own it if you say it, if it happens during and in furtherance. So the more you're saying they're really partners, does that mean that the error or potential error in the closing is more significant?
Well, for the focus on the closing, indeed, the Commonwealth or the trial prosecutor spent some time to talk about the text messages between the defendant and the victim. But the trial prosecutor also focused more on what the defendant said to the victim. Here, the victim's statements at trial really were just to provide context, that because it was a conversation between the defendant and the victim, it's not a one-side conversation or one-side communication from the victim to the defendant. It was that context was important, or was relevant to explain to the jury the relationship between the two, and in order to show the intent or the knowledge of the defendant on July 31st.
But didn't one of the arguments made by the appellant was that it overwhelmed the other evidence, this evidence of that was in all of the text messages, and isn't that the point, that there was such focus on the context that it overwhelmed whatever happened that night on July 31st? And that's the whole fear of prior bad act testimony, isn't it?
No, Your Honor. I believe Justice George is talking about the prior bad act, where the defendant argues that the text messages submitted overwhelmed the case because of the sheer volume of those text messages.
Sure.
If you look at Commonwealth v. Robertson, an appeals court case where there was 4 to 6 years worth of prior bad act that happened 10 years before the charged crime, the appeals court in that case held that it was because the substantial probative value of the case, those messages did not overwhelm the case. Here you have 6 weeks worth of text messages. And if you look at the exhibits in the supplemental record appendix from the Commonwealth, those actually only consist with 9 days of text messages.
Maybe so, but a very smart judge once told me, if I really want to see what was important to the Commonwealth, to read the transcript of the closing argument. And in that transcript, the Commonwealth made really, really clear to go through the weeks before the 31st, to lay this foundation to show that this is what was going on. So isn't that exactly the fear of why we say there should be a limitation on this, and maybe that this went too far, that it was really being convicted on all of that other stuff and not necessarily what happened that night.
No, Your Honor. Of course, the Commonwealth's focus in closing is one factor to evaluate whether the evidence was overwhelming to a point that prejudiced the defendant. Here, of course, the evidence was prejudicial because it helped to convict the defendant. However, if you look at other factors where the evidence, that the testimony was detailed and the amount of the testimony or the amount of text messages, when you evaluate these, especially when the text messages were substantially probative to the Commonwealth, where you have an immunized victim understand lying about what happened on the day of July 31st, where she testified that there was no communication between the defendant and the victim, where the text message show that they did communicate, where the defendant say, okay, in responding to the victim the text message of I'm good. When the text message's probative value is so substantial, that will outweigh any unfair prejudice if there's any. Here, the text messages were limited in time, in the scope, and in the amount, where it was 9 days, 6 weeks prior to the charged crime. It was limited and it did not overwhelm the case.
Mr. Lee, not only did the judge here not make the findings of during and furtherance of the conspiracy, she didn't submit the finding that she's required to the jury, nor did she analyze whether separate and distinct from all of these statements, whether the joint venture or the conspiracy existed. Does all that add up here to a substantial risk of miscarriage of justice?
So the judges, of course, the judge should have made a preliminary finding and should have instructed the jury on making their own determination based on preponderance. And it certainly adds to the evaluation or analysis of substantial risk. However,
But don't forget also make a determination of whether the conspiracy exists independent of the statements. She didn't do that either, right?
no, there was no preliminary findings. However, the fact that the judge admitted these statements showed that she necessarily imported those preliminary findings. This court's decision in Commonwealth v. Baker, where this court affirmed the judge's admission of business records without making these preliminary findings.
Did the cell phone communications play into that, as Justice Lowy asked you? Because those are the cell phone communications, those 9 weeks that are so damning, are those admitted as co-conspirator statements?
In motion eliminate, yes.
Okay, so we have to find, or the jury should have found and didn't, that there was a joint venture independent of anything involving the defendant and the victim, correct? Including the cell phone records.
Yes, it would be independent of the victim's statements. However,
You don't see that as a problem?
it would be better practice, and it would have been better in this case if the judge made a finding and gave the limiting instruction. However, where the standard is substantial risk and there's evidence that the defendant drove the victim to provide sexual services, and in his cars, all different items, lubricants, and female IDs.
That's really the only evidence independent to prove the joint venture would be dropping her off and having the implements in the car, as well as the cards, right? The
No,
business cards.
one key part is the defendant's text message to the victim. Those statements were independently admissible under A1D2, where it is a statement by a party opponent. The court could consider those statements.
Well, that's why I asked you, because you didn't say that before, as to whether or not his side of it comes in as a party opponent admission versus co-conspirator statement.
Those statements will be independent admissible as statement of party
But
opponent.
that wasn't part of the motion to eliminate, correct?
It was not.
Right, so everything was admitted as co-conspirator statements. This whole theory of admission is kind of backfilling to try to come up with another theory why it would be admissible, right?
No, Your Honor. I would like to correct myself. In the motion eliminate, when in the motion eliminate on April 10th, the Commonwealth did bring up two motions. One is the motion eliminate to admit the defendant's statements as party opponent, and there's a separate motion eliminate to admit the victim's statements as co-conspirator statements. So there was a motion eliminated to admit the defendant's statements independently.
And the judge allowed both.
Correct, Your Honor.
Okay, thank you.
So this expert witness has important testimony because your average juror doesn't necessarily know and understand sex trafficking. And additionally, this witness is a recipient witness. So doesn't that reality as an expert, they're looking at this person on the witness stand as an expert about important testimony. Doesn't that augment his credibility in the eyes of the jury as a recipient witness and perhaps lean into vouching? And isn't that concern what we have raised numerous times?
I see my time is about to expire. May I respond?
Oh, please, yes.
For the first question about the discovery violation, the defense counsel.
I ask you about that, and I know you have a limited amount of time.
Sure. So in terms of Detective McManus testified as both an expert and recipient witness. Care was taken in this case where the detective was not officially qualified in open court that he was an expert. There was limiting instruction at the final charge where about expert testimony. And Detective McManus did not testify to the ultimate issue or even to opine on the final question of guilt or innocence. All he did was provide information about relationship between a pimp and prostitute to provide a general sense how sex trafficking works. And only one close question is when he was asked to draw inference or to explain the significance of certain items found in the car. All he said was it's a control tactic. He did not say that the defendant was a pimp or these items were consistent with sex trafficking where you usually see in a drug case. All he said was it's a control tactic. He did not cross the line. And if you look at Commonwealth v. Tanner, an appeals court case where a detective only to describe this general understanding of how things works, he does not cross the line even when the recipient witness testified as an expert.
Okay, everybody else set?
Thanks, Chief.
Thank you very much,
Thank you. Your
both
Honor.
of you. Okay, we'll take our morning break.